Terrorism trial court strikes out Nnamdi Kanu's suit against FHCCJ. Good morning, good afternoon, good evening. Welcome to Emissaries News. Now we bring you the topmost of the top news where they happen all over the world. Don't forget to like, don't forget to comment, don't forget to subscribe, don't forget to share. Don't forget to on your notification button so that whenever our news drop, you will be the first to see it immediately or you're listening to the news proper. The Federal High Court sitting in Abuja on Friday struck out a suit he detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, filed to challenge the conduct of his trial in secret. Kanu, who is facing a terrorism charge the federal government preferred against him, had in the suit marked FHC/ABJ/CS/550/2022 queried the legality of a new practice direction that was signed by the Chief Judge of the High Court, Justice John Tosho. He contended that the said practice direction was illegal and unconstitutional and ought to be declared null and void. The IPOB leader prayed the court to declare the provision of Order 3 of the Federal High Court Practice Direction on Trial of Terrorism Cases 2022, were already the subject of Section 36, Bracket 4, Bracket A, and Bracket B of the Constitution of the Federal Republic of Nigeria 1999 as amended, and therefore obtuse, inoperative, and outrightly ultra-virus. Cited as defendants in the suit were the CJ and the Chief Registrar of the court. Justice T. Social had issued the contentious practice direction in the exercise of his constitutional powers as enshrined in Section 254 of the Constitution of the Federal Republic of Nigeria 1999 as amended. According to the new direction, proceedings in terrorism cases will be held on camera or as may be ordered by the trial judge. Proceedings of offense of terrorism subject to the provision of Section 232 of the Administration of Criminal Justice Act 2015 and Section 34 of the Terrorism Prevention Act 2011 as amended shall be held in camera or as may be ordered by the court. The names, addresses, telephone numbers, and identity of the victim of such offences or witnesses in the proceedings shall not be disclosed in any record or report of the proceedings, and it shall be sufficient to designate the names of the victims or witnesses with a combination of alphabets. In any proceeding where the court deems it necessary to ensure the safety and or protect the identity of the victim or a witness, it may take any or all of the following protective measures. Hold its proceedings at any place to be designated by the Chief Judge, and in the case of the Abuja Judicial Division, the venue for the time being shall be the premises of the Code of Conduct Tribunal. Received evidence by video link permit the witness to be screened or masked. Receive written deposition of expert witnesses. Direct that all or any part of the proceedings of the court shall not be published in any manner. Exclude from the proceedings any person other than the parties and their legal representative. Make order as to any electronic device that will be allowed during the proceedings. Make an order or any other measure that the court considers appropriate in the circumstances the direction read. However, Kanu, in the suit he filed through his lawyer, Mr. Ifeanyi Ejiofor, among other things, sought an order of perpetual injunction restraining the defendants, whether by themselves, servants, agents, privies, and all other officers and agents of the Federal High Court of Nigeria from applying and enforcing the provisions of the Federal High Court Practices Direction on Trial of Terrorism Cases 2022. Meanwhile, at the resumed proceedings in the matter on Friday, Kanu'S lawyer Ejiofor applied to withdraw the suit. Following his application, Justice Inyan Eko struck out the matter. Speaking with the newsman after the proceedings, Ejiofor said his client decided to withdraw the suit, having realized that he was not the target of the said practice direction. Meantime, the court on Friday fixed December 14th to hear another suit that Kanu filed to challenge his alleged forceful and extraordinary rendition from Kenya by the federal government. And people, now so we see him today for Emissaries news. Now we bring you the topmost of the top news where they happen for all over the world and all over the nations. As you can see this morning, talking about a terrorism trial that court has struck out Nnamdi Kanu's suit against the Federal High Court sitting in Abuja. Federal High Court sitting in Abuja on Friday struck out a suit. The detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, filed to challenge the conduct of his trial. And looking at the issue, looking at the case, this is the case number mark, that's FHC/ABJ/CS/550/2022, and the legality of the practice of judging Mazi Nnamdi Kanu in privacy has been queried, and after it has been looked into, the Kanu and his legal team has discovered that the particular practice was not or directions was not targeted against Canada, that it has been there even before now. That is according to 1999 Constitution as amended, that all those things are written and are documented. They are all written and are documented. So the target is not just about Kanu. It has been in the Constitution as amended according to 1999 Constitution. And I think as it stands now, Kanu and his legal team has given up on that, having realized that that practice or direction was not for personal target, but it has been there. Let me show you something. Also on trial of terrorism cases 2022, we are already subject of section 36 bracket 4 bracket A and bracket B of the Constitution of the Federal Republic of Nigeria 1999 as amended, and therefore odious, inoperative, and outrightly ultra vires cited as defendants in the suit by the CJ and the Chief Registrar of the courts. Also, Justice Tosho had issued the contention practice direction in the exercise of his constitutional powers as enshrined in Section 254 of the Constitution of the Federal Republic of Nigeria 1999 as amended. So, what Justice Tosho issued out on how a terrorism case should be judged as regards with MNK, who is Ohamadike one and the leader of the indigenous people of Biafra. Of course, you know that he is the spearhead that has been spearheading the struggle of the indigenous people of Biafra. And what he's fighting is not just any other thing, but it's just self-will and self-determination. Of course, you know that according to the UN Constitution, and also as it is enshrined in the Nigerian Constitution, that self-determination is legal, and also self-will is very legal. So the issue now is that I think Mazi and the Kanu's legal team and the FG legal team are trying to strike a balance. And what Mazi and the Kanu's legal team are looking into now is where terrorism charge came into this case. Of course, you know that Kanu is facing a terrorism charge or treasonal felony charge. That is the case that he's answering in court. But for him, he said that what he is doing, he is just a freedom fighter and he's a prisoner of conscience. And because his people, the Southeasterners, have been marginalized in Nigeria, and he decided that his people will go. Pharaoh, let my people go. Of course, you know that such a thing happened also in Catalan. As it stands now, Catalan are on their own. They have become a place of their own, moving out from Spain, and there was no shootout. There was no, everything was done legally. And I think that that is what Mazi Nnamdi Kanu is looking at, to have a free and fair referendum, and also to make it to be as legal as possible, as legal as possible. Let it be in a written document so that there will be no war or any barrier of gun. Don't forget that you are still on Emissaries News. Let me draw the curtain here. Don't forget to like, don't forget to comment, don't forget to share, don't forget to on your notification button so that whenever our news enter, you will be the first we will see them. God bless you.